Welcome to the webinar. My name is Marty Schenkman, and I'm joined by my friends and colleagues, Alan Gassman and Jonathan Blottmacher. And we have a riveting discussion that will assure you fascinating topics for any holiday meal. You'll entertain everybody. We're going to talk primarily about LLC, but about other entities to a degree as well, about provisions that may go in the governing documents and some planning ideas to help backstop some of the estate planning that's been done. And it's interesting. I believe we have a few new ideas that haven't been discussed. We have a few ideas that may have been discussed that have been discussed before, but hopefully we'll give you some insight on it. And with Alan and Jonathan, we never know where it goes. I'm going to run through very quickly a couple of pointers. The materials will be on, Alan, you post everything to your website?
The Estate View website, yep.
Estate View website. We're going to have it on Schenkman Education. Peak and ILS will have it as well. We don't give CPE or CLE, so forgive us, but hopefully you'll get good, valuable information. There's a disclaimer in case you were concerned we weren't actually lawyers. We have a whole bunch of sponsors, and I'm just going to rattle their names off so we don't waste much of your time. Interactive Legal, which is a drafting software company that Jonathan helped found. I use it. I believe Alan uses it. It's part of the technological revolution of our practice. Peak Trust Company, which Jonathan has also been instrumental in, is a administrative trust company with offices in Nevada and Alaska. It's a great company. I'm on the phone or emailing with Abby O'Connor, who's is she general counsel or trust counsel?
She's chief fiduciary officer. She's basically almost the equivalent of general counsel because she's not only a terrific person, but she's a great lawyer, and she's a member of the Alaska bar as well as the Florida bar.
Very smart, and we discussed some of the topics here today and what trust companies are doing, and I can certainly say that they are on the forefront of a lot of these issues and questions, and they're very proactive because they're nimble to try to address them. I've done a ton of webinars and articles over the decades of practice, and I'm moving them all to a new website, Schenkman Education, just to make it easier for people to find. It should all be there. And now here we go. So we're going to talk about mostly, but not entirely, drafting tips for LLC operating agreements that backstop estate and asset protection planning. And Alan, I think the last slide is like 5 ideas of yours. So when we get there, I'm turning the mic over to you and you're going to run. So this slide is just an idea that I've used on some large clients. One of the challenges, let's say a client has some real estate properties, entities, and they're going to set up 2 non-reciprocal slats or a slat and a spat, and they're going to do note sales, and you may carve out a slice of the entity, and we'll talk about this briefly, as a special voting membership interest and sell that to another trust. And, sometimes we break it up into multiple trusts and transactions just so it's a little more creditor difficult to reach and a little more difficult for the IRS to attack. In other words, if we're using a particular type of transaction to transfer interest to one trust, we'll use a different type of transaction structure for another trust and replicate it so that it's more difficult to challenge. When a client has 2 or 3 LLCs that own underlying properties, the paperwork's not so bad. But often you'll run into a client that has 20, 50, 100, hundreds of separate properties. One of the things that we've used in some of these cases to just simplify the paperwork, and I'll tell you a little war story, which Jonathan and Alan can comment on, is we'll create like a master operating agreement. And then Exhibit A is going to be a chart of every single entity and who's authorized to sign as manager of the entity and members of the entity. And the exhibit after that will be, a lot of times we'll have a deal that there may be another equity holder in or some special arrangement for. But out of 50 or 100 different LLCs, there may be 10 special arrangements and 99% of everything else is identical. We deal with the 1% that's not identical in an exhibit, but this way we can have one operating agreement govern 100 different transactions, 100 different entity holding companies for the underlying real estate. And when we make a transfer, it's one assignment, one operating agreement. and I'm curious how you guys feel, if I'm making, let's say, a note sale to a trust, I want to have an operating agreement before the note sale reflecting everyone that's the owner pre-transaction. And then the next step, when the sale occurs, I want a new amended and restated operating agreement that reflects the owners and the Wandry valuation or uh, Christensen valuation structure in that operating agreement. And many of the transactions that we've done and you've done, all of you, you may have 3, 4, 5, 6 steps in the process, and they may go on over a period of time. Having one operating agreement instead of 100 can really make it practical to get it done. The deal that I came up with this on, we were working with a law firm not to be named, no offense to our colleagues, and they were going to draft like 82 different operating agreements. And I said, no, we can't do that. Alan, Jonathan, thoughts, comments?
Let me ask you a question. Are you talking about someone who has 80 or 100 different pieces of real estate?
Yeah, each in a separate LLC.
What would this?
We'll have those LLCs owned by, if you will, a master or parent LLC, so that we can have one governing document. Or
And
even if they're separate and we don't have it owned by a parent, we're going to create one LLC operating agreement that they all subscribe to.
well,
Wow, that's
if it's all the same, Marty, do you run the risk that someone's going to say, "Hey, these aren't separate entities"? I mean, you've got it all tied in one place. Why should
They
we
are separate
respect the separate
entities.
nature?
It's just minimizing the paperwork. They are separate entities. They're each separately legally formed. And let's not get into, but that's a separate discussion, is the series LLC that, for example, Delaware permits. That
Right.
always makes me nervous about consolidation or an argument like you're
It
making.
makes me nervous as well.
I
I
I
mean,
I don't think it's
Marty, one of the
possible for 100 different operating agreements to be done properly and signed, especially if you have 5 steps in the transaction. It's 500 operating agreements. It's never going to happen.
well,
I'm not dismissing your comment at all. It's something I would apprise the client of, but I also don't think it's ever going to get done right if there's that many agreements. Although
well,
the legal fees could be good.
I would agree, Marty, and I mean, I've had clients with many properties, but typically we hold some in one entity and some in another entity. I've never had someone come in and say, I have 75 different parcels of real estate and I want each one in a separate LLC. That would be unwieldy. It really would be.
And that's how we're trying to wield it in so we can do the estate planning.
Right.
Exactly correct. Alan, any thoughts?
no, I think you guys have both stated the considerations that come to mind.
So one of the things that I proposed doing, which I haven't seen done, and it just kind of came to mind when we were working on an agreement this past week, is add a provision to the operating agreement that says if there's a fixed dollar sale and if it is not listed on a tax return or a trust or other third-party record, those third-party records and tax returns are not controlling. The operating agreement remains controlling despite that.
I
It
like that.
doesn't solve the problem, but it's giving you an argument that if the service or a creditor comes in and says, no, you still own that interest, it's not in the trust and outside of the reach of creditors or outside of the reach of the estate tax. No, those things are not determinative of what this is. It's no different where you provide contractually in any kind of transaction that if there's a conflict between an exhibit and the main contract controls. It's the same thing. These ancillary documents don't control. We all agree that the fixed dollar value ownership interest as specified in the operating agreement controls. That was the thought I was trying to get out. Alan, I'm going to ask you for comment.
First of all, I'm not sure the IRS had that great a position in Sorensen to say that you really have to make everything, this is what we think the ownership percentage is. If you, in good faith, think that 2 million was 40%, it seems to me that you just report it that way and that no one should be harmed by that. But the IRS in Sorensen filed pleadings, not to a court. The court never decided anything in Sorensen, it settled, but the IRS filed pleadings saying this should have been adjustable. And Marty, you're right. If the operating agreement says we will respect this valuation clause and what happens here in the operating agreement is what everyone will have to respect. I see no problem with that type of provision, and it does disarm an IRS agent who wants to make a deal out of that part of the Sorensen pleading.
That's
Well,
the point. I think it gives you a different strategic edge when you sit down to trade with the service or a creditor that somehow because we all make foot faults. The stuff gets complicated. There's a lot of different people involved. Foot faults happen. And by the way, on the Sorensen case, the reason the taxpayer was happy to settle it, actually, the company sold for so much money, they were better off paying the gift tax because they got a huge amount out of the estate based on future appreciation or
Yeah, I mean, they were better
post-transaction.
off. By the way, if I could just interrupt, almost everybody is better off not having any adjustment, but instead just paying a gift tax to get that discounted asset completely out of their estate, to get the grantor trust rules working on it, to get all the growth out of their estate. Most of us would be better off without these adjustment clauses. The only reason we use them is because everyone else uses them and because we don't want to pay gift tax. But throw me in the briar patch, IRS. That's what the Sorensen said. You're right. It was a big old gift. It's all out of our estates. Thank you very much.
Well,
Right.
Alan, your statements show great wisdom on your part, and I've had that happen. I had a case up in Buffalo where I mean, we had it, and the group manager said, I put in a dollar amount, and the group manager told the estate tax attorney, "You have to respect this. This was a gift tax matter. You have to respect this." But she just wouldn't. She was just vehement. And we finally wound up paying the IRS an additional $200,000, and we got 250 million out of the estate. So, Alan, you're very wise to say, you may be sorry what you asked for, but that's really true. Let me ask you guys a kind of an important question here. Uh, if you have an adjustment, what is the effect of that adjustment? Because let me ask you guys a question. You both bought homes and other things. And Alan, when you bought your home, you went to, the Mr. Smith or Mrs. Jones and said, "I want to buy your house and I'm willing to pay 800,000 or whatever it is." And you do it as of that date that you sign the contract with her, not the date of closing, right?
That's right.
Have you ever said, "Oh, by the way, we're going to have to adjust this if it turns out at the date of closing that the value is different"? Marty, have you ever done that with something you purchased? No? Then why are we doing it in the estate planning context? This is supposed to be, and that's one of the things, Alan, I know you sent me this note about the King case today. But nobody does deals like that. Nobody says, "Well, we're going to pay you $75 or whatever it happens to be, but if at closing we think it's different, we're going to adjust the price." Nobody buys things that way. And that's one of the reasons that the court didn't prey on it. But I would have said to the court, how can this be arm's length when no one in the entire universe writes a contract where you have an adjustment? I think
I,
adjustments
I I
are
don't know that I
dead.
fully agree with that. I mean, people do transactions where there's earnouts based on future earnings or adjustments based on future information.
Yes, but it doesn't change the basic deal they made at the beginning, Marty. I've never had a client say to me, "Well, I'm going to pay 100,000 for this, but we've agreed if it turns out that the value is different, we're going to adjust the price."
Alan, let's go on to a new topic. In Powell, the taxpayer, in conjunction with others, could control liquidation or distribution of the entity. And as a result of that, the assets were included back in their estate. So when we're planning for a transfer of, say, an LLC interest, one of the issues to address is, can we can we draft around the control that the client would have over, in particular, these two tax sensitive powers? Now, I think the Powell case is viewed by some as being a bad fact case. It wasn't a real operating business. I think it was a passive holding company. So some argue that this may not apply to an active business. But perhaps the safer approach is to try to draft or plan to minimize the client's control over it. So some simply don't address it. There's another approach, Alan, which I know you've done, and maybe you can describe, where you create a special voting membership interest for decisions as to liquidation, distribution, or changing those terms in the operating agreement. Why don't you explain that concept and what you can do with it?
Well,
Right. And
Marty, Alan, go back and say what was the problem that the taxpayer had, and that I think will lead into everybody, including me, understanding better what you're talking about.
well, in Powell and Strange, the tax court said, and it was a full tax court in Powell, a full opinion, said you kept the right to decide if and when there will be a liquidation or distribution. And that is a retained interest under 2036A. So even though your 1% voting interest was subject to a fiduciary duty, the fact that you could tell that entity if and when to make a distribution caused you to be subject to federal estate tax, even though the entity was pouring into a separate irrevocable trust that you didn't control. So what we do is we have a 1/10 of 1% special voting member interest or special general partner interest, and only the owner of that 1/10 of 1% interest controls if and when there will be a liquidation or distribution. The donor may own a 9/10 of 1% voting member interest or general partner interest, which entitles them to control the voting and to control the management of the entity under a fiduciary duty, but not to make decisions with respect to liquidation or distribution. And then the 99% interest may be sold, gifted, what have you, to a separate GST trust, almost always. And the trustees of that GST trust and the trustee that holds that special member interest of 1/10 of 1% are not the same two people. In Powell and Strange, the court went out of their way to say, well, this power to make liquidations and distributions was held by a family member who was also the agent under your power of attorney. So we need to make the trustee of the trust that holds the liquidation or distribution power someone or an institution that's not otherwise directly involved with the client and does not otherwise, at that point in time at least, occupy a fiduciary position. We will typically set up what we call a grandchild trust. This trust is only for the benefit of grandchildren and descendants of grandchildren. We gift it or sell it that 1/10 of 1% voting member interest. We have a trustee, as I said, who's independent from all the other trustees and fiduciaries involved. And we think that will hold up. And we've been told by people like John Porter and others that that should hold up.
When you do that, and then distributions are going to be made, have you had that situation? What do you do?
Of course. Well, you give you have the distribution approved in writing
Yes.
by the trustee who holds that liquidation distribution right. You don't forget to do that and completely ignore it. And then you give 1/10 of 1% of the distributions to that trustee who then spends them or holds them for those precious grandchildren.
Yeah, no, that's exactly correct. And I think that's where a lot of people will also trip up because the formalities are just too often overlooked. When we've done this, we've created a template that the trustee can use with the underlying entity to authorize a distribution. And then, as you said, we make sure it's pro rata.
Alan, do you worry about the family having the right to change everything? In other words, you have this agreement, on its face, it's binding, but the people could go back in and change it. And could they change it retroactively?
We do give the grantor the power to replace the fiduciary with an unrelated party. Because from a practical standpoint, the client says, wait a minute, you want me to appoint my new CPA to be the trustee of the grandchild trust with this power? What if she turns out to be a creep? Well, you can replace her with an alternate, non-related party. And that doesn't bother me.
Marty?
I agree. Not related, not subordinate.
Right. You've got to
Guys, do you think, Alan, you kept saying in a fiduciary capacity? What does that add or not add to what you're trying to accomplish by saying it's in a fiduciary capacity?
on the liquidation and distribution right, I don't know that it's important that it be in a fiduciary capacity, but it sure feels like the IRS wants to see that in a fiduciary capacity. And I guess that means you're not subject to being bribed by the grantor to make a liquidation or distribution. When you're in a fiduciary capacity, you're at arm's length from the grantor.
Well, this kind of reminds me of the argument the IRS has made a couple of times that if you make the control in such a small infinitesimal piece of the equity, that the other people would just come in and pay a high price for it, and therefore the grantor has it back. Now, the IRS has not been totally successful in that regard, but it has been raised by the surface, and I'm not sure they would lose it, especially if you had egregious facts.
Well, you could make it non-transferable.
Well, you know, the law doesn't like things that are non-transferable, and they're often declared, you know, completely invalid. I think I'd like to have a situation where maybe it appeared more businesslike, more things that people in business would do. But maybe that's just me.
Yeah.
That's one of the options we're coming to. Next slide when we get there. That'll be exactly one of the options. Another approach I've seen some use is to create just to specify authorized members. So in the operating agreement, without creating a special interest that's sold, for example, to another trust, to avoid the need for yet another trust, you create authorized members, and only those independent authorized members can make decisions, obviously not the transferor, as to decisions concerning liquidation and distribution or changing the agreement as to those rights. And I've seen that done as well. Where that gets a little complicated is if you have trust members, are they authorized members or not authorized members? And if the settlor, the donor, the transferor, is the investment advisor or trustee of the trust member, then they've in effect got the right that way. So you have to be mindful of that. You could require perhaps, and I'm curious if you guys think this is sufficient, that for trust members, if the settlor is the investment trustee, require that an independent trust protector consent to any or make any decisions as to distributions and liquidations to avoid it going back inadvertently to the settlor, the transferor. Any thoughts?
Is that trust protector a fiduciary?
I think they should be in that case.
I think that would work if they're a separate independent fiduciary.
Yeah. The idea is just to avoid having to create yet another trust, but you end up with hoops through whichever approach you use. Another approach is, Jonathan, what you were mentioning a second ago, which is a business judgment rule in terms of just applying business standards so that it can't be done in a self-serving way that is control. Thoughts on that?
That's helpful. It doesn't hurt.
I mean, I think one of the points of all of this is in many cases that we've seen, no one addresses this at all. So I think if you do something, you're probably, you know, ahead of the curve in terms of at least compared to others that have not addressed it. I don't think there's a clear answer on how Powell gets applied when you have a real business. I don't know that if Powell is going to be applied in cases where you have any of these methods that you've at least tried to distance the transferor from being able to control those two powers of liquidation and distribution. So there's a lot of different options, and I think whatever makes sense in the context of the transaction, something could be looked at and at least offer the client options. Any other comments or thoughts on this?
No, I think you've got some great ideas.
Okay, Alan, it's your show.
Oh, okay. The other things we put in LLC operating agreements. For one thing, if you mix assets in an LLC taxed as a partnership, you can trigger gain under Section 721B.
Let's just explain what happens if you pass diversification tests, which are very mechanical, not intuitive in the least. You have to really calculate it to see if it triggers it. You could have Al and I and Jonathan put some securities into an LLC, and now we each own a third of the LLC. Bam, because it's a partnership, we've each diversified our portfolio. You think it's tax-free under 721, but because of the investment company rules, which go back to the corporate income tax provisions, you've triggered gain. Alan, how does this compartmentalization solve that problem?
Well, if I make a contribution to this partnership that would cause that tax to be triggered, my contribution goes to a separate compartment, so to speak, that doesn't get mixed in with everything else.
So that just becomes your asset?
Becomes my separately allocated capital account asset and is not shared with the others. And then the percentage allocation stays the same. There's not an adjustment in percentage of ownership. That's just a savings clause in the LLC agreement.
Makes sense. It's an interesting concept.
I
think a lot of people do these security transactions with FLPs and LLCs, not even realizing that rule's out there. So if they at least put this in, they got a safety valve if they get caught.
Right.
They get tripped up.
Right. The second one goes back to the Hackle case. I don't know if you remember the Hackle case, but Mr.
HAKL.
Yeah, he made a big gift into an irrevocable trust, and the LLC or the partnership agreement didn't allow transferability. So the IRS came in and said, "Well, this isn't transferable." So the Crummey withdrawal power holder wouldn't have been able to withdraw it. Later, Mr. Hackle came to me for estate planning and said, "I want to make sure this is addressed." So I put a provision in his partnership agreement that said it will be transferable to the extent necessary to allow a transfer under a Crummey withdrawal power. And he thought that was a good idea, and John Porter thought it was a good idea. So that's what we've used ever since.
Just so it's clear to everyone, the problem is that to get your annual exclusion gift, it has to be a gift of a present interest. But on the flip side, every time we do an operating agreement or a partnership agreement, we want for both asset protection and discount purposes the most onerous provisions that you can draft. But if you draft onerous provisions that may be safer from an asset protection perspective for a creditor, you now have probably eliminated the ability to qualify for an annual exclusion gift. So they're contrary goals, and Alan's given an elegant way to reconcile them.
Right. Then the third item is at least in Florida, we have a solid case law that says that I could put in my operating agreement that my LLC ownership interest on death automatically is owned by Marty Shinkman. So
I love it, Alan. You got a lot of money in there?
Yeah, I do, like $6. So it's a pay on death feature that you can just put in the operating agreement. If you're not sure if that will work, you can of course hold that LLC ownership interest under a conditional assignment or hold it in escrow or something like that, or better yet, put it in a revocable trust. But these pay on death provisions aren't so bad. The fourth one is people forget that while you may have charging order protection if you own, say, 80% of an LLC under state law, if you go into bankruptcy, then the bankruptcy code basically does away with your charging order protection unless the LLC operating agreement is what you call an executory contract, which means that both parties have obligations. Well, people want to put money into an LLC. They don't want to have capital call provisions. But you may want to go ahead and put a provision in there that the manager can call, at least for a small capital call, that people have to attend meetings, that people can't compete. You want to have some executory contract characteristics in your operating agreement if you want charging order protection and you think that the member could end up in bankruptcy.
And
And
Alan,
Alan,
go on.
and I assume you're going to want to make sure that really happens. In other words, you can have the provisions there, but if they're ignored, or that, you've got nothing.
Right, but a provision saying that the manager can require a capital call doesn't necessarily have to be activated until the bankruptcy occurs. It's still a legitimate
Well,
provision.
yes, but I think it would be good to actually have it happen, to
Right,
show it was
right,
respected and you weren't just doing it, when you were under the gun.
right, right. Then next, we see a lot of operating agreements where LLCs are taxed as S corps, and it violates the second class of stock rule. You really have to be careful. In fact, that's where AI is pretty wonderful. If you run an LLC operating agreement through a good AI engine, it will tell you all the second class of stock issues, but you at least want to have a savings clause. And that savings clause should require that there would be no uh, obligation to ever sell or ever transfer or buy ownership interest for less than book value under generally accepted accounting principles, because that's one of the second class of stock provisions. And then finally, yes,
Alan, explain that in more detail. If you have an S corp, they can have different entitlements to distributions, but they can't have two different classes of stock. You have different voting rights, but everybody's got to have the same equity type interest,
got to have everybody has to have the same distribution right.
It can
right?
only vary by voting right.
No capital accounts
Right?
whatsoever. It can vary by voting right. And if you leave the partnership, Jonathan, I can't buy your interest out for less than book value as determined under generally accepted accounting principles. And we see violations of this all the time. Every time I get a new operating agreement for an S corp LLC, I cringe before I read it because I know I'm going to find a problem in there most of the time. But fortunately, there may be a savings clause that bails you out of that.
What
And
would that savings clause say, Alan?
it would say that no provision under this agreement or under any amendment to this agreement will have any force or effect if it would cause less of the loss of the S election under the second class of stock rules, and there will never be any capital accounts, and distributions will always be pro rata ownership, and no buys or sells of any interest for less than that book value under GAAP. So at least that's a good try to keep it out of the second class of stock rule catastrophe.
Yeah, because if you have a second class of stock, you permanently lose your S status.
Right.
And that means you may owe an awful lot of back income tax.
Right. Because you go and look at an agreement that's 12 years old and say, oh my gosh, for the last 12 years, this has been a C corporation. They've been reporting it as an S. Thank heaven for the statute of limitations, but it's still a big problem. And then finally, for clients who are in tenancy by the entirety states, like Florida, Delaware, Wyoming, and many others, there's 6 unities of tenancy by the entireties, and the married couple has to truly be joint and survivor. You can't have a buy-sell agreement that says, well, if Alan leaves, this is what happens to Marcia. If Marcia leaves, this is what happens to Alan. Or if they get divorced, Alan can buy out Marcia. That's not going to work in a tenancy by the entirety state. So you may be opening up the assets of that LLC to creditors of one spouse or the other when they think they have protection. So if you have a married couple that's buying into an LLC taxed as a partnership, have them set up their own TBE LLC to own the interest in that LLC, or very, very carefully examine all the provisions of that LLC, hope that there's a tenancy by the entirety savings clause, and then hope that somebody doesn't accidentally amend that agreement and cause loss of any of the 6 entireties so you don't lose your creditor protection. So
Alan, give us more background about the tenancy by the entirety issues here.
well, tenancy by the entireties, by definition, means joint ownership where the married couple is one entity. They have to take their ownership interest at the same time. That's unity of time. They have to own it together. That's unity of title. And it takes both of them to sever the interest. So those unities are strictly construed in most of the tenancy by the entirety states. And for that reason, a lot of people open joint accounts and they think they're tenancy by the entireties accounts, but because the account is missing one or more of the unities, they don't have the creditor protection that they expected.
And that creditor protection is provided under state law for tenancies by the entirety. So unlike a joint property, even with rights of survivorship, if I'm sued, the creditor might be able to get my half, but he can't get my wife's half. But with a tenancy by the entirety in states like Florida, you can't get either.
That's right.
Do you know which other states permit tenants by the entirety for other than, say, a primary residence?
I know Pennsylvania, Maryland. I don't have the whole state, the whole list. Tennessee has a lot of good protection, but some states allow tenancy by the entireties, but they don't protect it from creditors. So you have to be very careful when you look at the list.
No, it's very state specific, but where it works, and you're saying it does in Florida, it's a very powerful tool for asset protection that may be a lot easier than a lot of the other approaches we may use. You
Well,
just got to make sure state law works.
I've had many Pennsylvania lawyers say, we don't bother with all this fancy dancy, asset protection stuff that you do or you devise, Jonathan, because we just use the tenancy by the entirety. Now, of course, considering that more than half of American marriages wind up in divorce, that may be kind of temporary. And Alan, let me ask you a question. Suppose, okay, I'm going to do this tenancy by the entirety, and my wife has to agree if we want to change it. Can she make me her attorney in fact for purposes of changing it?
You
I
could
don't know
give
the
each
answer to
other,
that question. I'm just asking.
well, no, you can give each other powers of attorney, but she would have to act in a fiduciary manner as to your common interest.
Why is that? I mean, if my wife and I take a piece of property as tenants by the entirety, but she gives me a power to on my own to change it from a tenancy by the entirety to say joint property or even to a tenancy in common. Is there any reason she can't do that?
I would think you wouldn't have unity of interest.
Oh, you don't?
No, I don't, unless she gives it to you in a fiduciary capacity as agent under her power of attorney. I think that would be fine. But if she just said, well, it's not really equal if you can sever it, but she can't, it's not truly equal.
I wonder about that, Alan, because I'm just giving her this power. But again, I just raised the question. I don't know the answer.
Yeah. Yeah.
So why don't we make a few sort of closing or concluding comments? What we've tried to do is present a number of different estate and asset protection perspectives on entity governing documents using primarily LLC operating agreements. And I think it's fair to say that we all see a lot of situations where things are just not handled well. And one of the causes, I think, of this is that sometimes clients, corporate counsel that's doing an operating agreement doesn't appreciate or understand all the estate planning ramifications of it. And it's really important that somebody with estate planning background collaborate with corporate counsel if corporate counsel is drafting the governing documents, because they may just not be aware of or knowledgeable about some of these implications. I think another sort of take-home message is that a little more attention to some of the implications of the governing documents, not just making sure you have one, can really do a lot to help clients with planning. Alan, any comments, thoughts?
No, I think you've led a nice discussion here. I always learn a lot from you and Jonathan, and I love watching you bicker. It's fantastic.
Thank you. Jonathan?
Marty, I don't think I've got anything more to add. And as usual, I'm very resident about, making any comments.
Yeah, right. Thank you all for joining us, and hopefully you'll glean some practical implications and actionable ideas from the program. Thank you, Alan. Thank you, Jonathan.